Lady, thank you.
Mr. Tate, please raise your right hand. Two seventy five.
Yes, ma'am.
Either your right hand. Place it flat on the box. Okay, lay over than that again. Again, place it flat on the box. Okay, one more different side. You're imagining that things.
No, the older I get, the worse my hearing.
Thank you.
What'd you just say?
Okay.
The older I get. I walk right into that one again, Judge.
Okay, we have Centarius Marquise Chavis. I've got four cases. The one is to be dismissed. Let me pull that one out.
288, I believe, the one ending in 288.
Okay, 26 CR 288, unlawful possession of a firearm by a felon. I'm going to put that one just aside. Then we have three in numerical sequence. 26 CR 750. This is state jail felony, evading arrest or detention. Then 26 CR 751, third degree felony, unlawful possession of firearm by a felon. And to round out the field, 26 CR 752, the second degree felony, aggravated assault with a deadly weapon.
Correct, Judge.
Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Judge.
In summary, sir, 26 CR 750. Yeah, the first one in numerical sequence alleges that on or about December 1st, 2025 in Jefferson County, Texas, you intentionally fled from a person you knew was a peace officer attempting to lawfully arrest or detain you, evading arrest or detention, and that happens. But paragraph 2 goes on to allege that you have previously been convicted in County Court of Law 2 of Orange County, Texas for evading arrest. So paragraphs 1 and 2 thus constitute a state jail felony because of the prior conviction. So anytime you evade arrest, it's always going to be a felony now. You're looking at no less than 180 days up to 2 years in a state jail, and a fine up to $10,000 can also be assessed. Do you understand the punishment range applicable in this case?
Yes, sir.
Agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in prison. And I'm sorry, 2 years in a state jail.
Yes.
Yes.
And that would run concurrently with 2 other cases. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this indictment? Guilty or not guilty? And to paragraphs 1 and 2, by the way, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And this paragraph 2, which alleges that prior 2020 conviction of evading arrest out of Orange County, Texas, is that allegation true as it is alleged? And are you pleading true and correct to that voluntarily?
Yes, sir.
All right. Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report right on this.
Yes, Judge.
On this cause number 26 CR 750, state jail felony of evading arrest or detention with a prior conviction of evading arrest, I'm going to find Mr. Chavis, you're pleading guilty and true respectively to paragraphs 1 and 2, constituting a state jail felony of evading arrest or detention. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. And this sentence shall run concurrently with 751 and 752 that we are about to go into. Do you understand what has happened here in this case, sir?
Yes, sir.
All right, we now go into 26 CR 751 and 26 CR 752. And again, lest the defendant waive formal readings of these two indictments, can we proceed in summary?
Yes, Judge.
In summary, 26 CR 751 alleges that on or about December 1st, 2025 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by a felon. Do you understand what you're charged with there, sir?
Yes, sir.
And 26 CR 752 goes on to allege that you committed on or about December 1st, 2025 in Jefferson County, Texas, the second-degree felony of aggravated assault with a deadly weapon, namely a firearm. So do you understand what you are charged with in these two?
Yes, sir.
In 751, this is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
Agreement's been reached in that case where you would be pleading guilty, sentenced to 5 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
We'll put that one on hold for just a moment and go to 26 CR 752. And in 26 752, in summary, it alleges that also on or about December 1st, 2025 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, which means a second-degree felony means that you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in this case. You would be pleading guilty and sentenced to 5 years in prison to run concurrently with the other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 for each of these two cases, 26 CR 751 and 752. Did you sign those documents
Yes, sir.
voluntarily, understand them, discuss them with your attorney?
Yes, sir.
Are the contents all true and correct?
That's true, sir.
Okay, State's Exhibit 1 is tendered into evidence in each of these cases. Without objection, it's admitted. And in each of these cases, State's Exhibit 1 similarly states that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in each of these cases. All of this is true of States. So help you God. Correct.
Yes, sir.
State's Exhibit 1 is made a part of the record in each of all of these three cases, 26 CR 750, 751, and 752. And pre-sentence reports are right.
Yes, Judge.
I never follow these agreements. The only thing that's a hitch in the giddy up, as it were, is that this 752 case, there's going to be an affirmative finding
We understand,
that a
Judge.
deadly weapon was used, which means your parole is different, going to be different from the other cases. You're going to have to serve by law at least 50% of your time before you are considered for parole.
Yes, sir.
In these two cases, 751 and 752, I find, Mr. Chavis, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. In States Exhibit 1 admitted in each of these cases, I now find you guilty beyond a reasonable doubt of unlawful possession of a firearm by a felon, a third-degree felony in 751, and the second-degree felony of aggravated assault with a deadly weapon, 752. I'm following these agreements. In each of these cases, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 5 years. All of these sentences shall run concurrently with each other, and in 752, an affirmative finding on the judgment will be reflected that in that case, a deadly weapon, namely a firearm, was used in the commission of the offense. All right. Do you understand what's happened on all of this?
Yes, sir.
All right. And again, these sentences run concurrently. Fix all of this. I know you can do better than
Yes,
this.
sir.
Do it.
Most definitely.
Do it. You can do it.
Mistakes happen. I apologize.
And you're given credit for it. You will be given credit for all time you've served in accordance with these cases. But yeah, that's stable. And you have to know, yeah, this is like radioactivity. You've got your firearm, and that's a crime.
Right.
And that's another third-degree felony. You got to stay away from that.
Yes, sir.
Okay. All right. Anything else? That is all.
Thanks, Judge.
All right. You are Ashley Ann Presley.
Yes, sir.
All right. In 26 CR 65, you were here with Ms. Manali, your attorney, and the prosecution is here. As you know, you are charged with a most serious offense, a first-degree felony of trafficking a child for sexual purposes, is the way this is alleged. And this carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And a fine up to $10,000 can be assessed. Is there anything special about the punishment range on this statute, or is it just that regular first degree
Yes, sir.
or felony offense? All right. So they don't get much more serious in the allegations than this. Ms. Minaldi is representing you. This is an announcement. How long have you been in jail now? Months? How long have you been in jail?
Since February.
February. Okay.
Yes, sir.
Well, it's going to move one way or the other right now. What are we going to do?
She's requesting to set her case on the trial docket, Judge.
All right. It's going to be set on the trial docket. Here's some things, though, that the court has to order, because this is involving a child as an alleged victim. You nor anyone on your behalf can have any contact with this child.
I don't see.
I know. But
I'm
I'm not saying you
Yes,
did,
sir.
but I have to do the warning. If that happens, that's a crime, serious crime. And that gets stacked on top of trouble if somebody's got pending cases. Someone on your behalf as well. I don't want to hear that there's being pressure made on the child through someone else acting on your behalf. That would be serious for them, and possibly as well as you if you knew about it. We don't get it. And that's a good thing because of the nature. The statute, we don't deal with this often, thank goodness, because the nature of it is so serious. But there are different variations of what the punishments can be based upon the circumstances. And uh, is there anything that the defendant needs to know? It states under subpart D, and small case B. It was indicted as large case A, but I think it's subpart. It's a small case because they've got large cases and small cases letters in the.
Judge, it's meant to be capital A2, but B1 that you're looking at describes the punishment range. It details that anything under A5, 6, 7, or 8 is the first degree felony punishment range that she's indicted under.
And she's under 8.
That's correct.
And it's small case A, not large. There's this large case A, but it's a small case. I don't think that affects anything, and that's in the caption anyway.
Small case A8, and then is punished by small case B.
Because it doesn't. We're not talking about any of the circumstances that would fit a minimum 25 years.
Correct.
Is that right, everybody?
Just the first.
So it's going to be again no less than 5, no more than 99 years confinement of life imprisonment. Is the defendant eligible for probation under the statute?
She does not have any prior felony.
I know, but is this?
I don't.
Let's make sure it doesn't fall into one of those exceptions where there's probation is not allowed.
It would fall under, no, she would not be eligible for probation. Under 2802. There's no probation. It's under 42A.056.
Of the Code of Criminal Procedure.
Yes,
Correct, Judge.
Is that what you
Subsection
understand
6.
too? That this is not
6.
a sentence. If found guilty under this, she's not eligible for probation. So if she's found guilty, it's
Prison time.
prison. And
Yes, sir.
is this also treated as a 50% rule if found guilty and imprisoned under parole statute?
That I don't know, Judge. That's a whole different animal.
Well, that affects decision making sometimes.
I mean, generally, if you can't give them probation on it, then it's usually a half time.
Well, you know, put your phones on.
I think it's going to be in the government call. I think you're going to have to do it. Generally, if it's a 3G offense, what we used to call 3G on under 5.4, it's listed as one of those that you can't give probation on, which usually means it's aggravated.
Yeah. So also, your parole, if you are sentenced, the parole law may require you to serve any sentence at least 50% before you are parolable under this. So it's legislature intended it to have serious consequences. So we're setting it for trial.
Yes.
All right. It shall be done. And again, be careful about communicating with the alleged victim. Okay. Yes, sir. Office. That is all.